Business organization. Welcome to business organization. We are not talking about organization in the sense of arranging or putting things in place, but in the sense of the legal type of business you will establish, also called the business entity. This decision is important for many reasons, especially because tax and liability obligations differ based on the type of business. In this session, we will cover 3 important decisions every business owner must make: whether to go into business alone or with a partner or partners, what type of business organization to use, and what professional resources you'll need. In this session, we'll explore the following concepts. Should you have business partners? What is liability and where does it come from? What type of business organization is right for you? Steps you should take to organize your business, professionals that can help, and the top 10 do's and don'ts. Let's get started. Should you have business partners? First, let's define what a business partner is and what their role entails. The term partner should be reserved for individuals who will be actively involved in managing the business. In the early stages of starting your business, you may be tempted to trade ownership in the business for goods or services that your business needs to get started. Everyone with an ownership stake is a partner, and partners will have rights under the law. If a partner is fired or decides to stop working with the company, his or her ownership interest in the company may continue. Before deciding to make someone a partner or owner shareholder in the company, you will want to consider factors such as the individual's dedication, whether the individual will also be working for other businesses, ventures, or employers while also working with you, whether the individual's skills complement your own, whether the individual's work hours are similar to yours, whether the individual's vision for the business matches your own, the individual's track record in growing and running businesses and/or working with other partners. The nature of the individual's contribution to the business. Will he or she be contributing standard services that can be outsourced from other organizations? Or more important attributes, such as strategic advice, needing funding, or key intellectual property? There are many pros and cons to going into business with a partner. You'll need to weigh these pros and cons in order to determine what is right for you and your business. Here are a few examples. Pros of having a partner. There is safety in numbers. In other words, you have 2 heads instead of 1 to discuss issues and make decisions. You will have someone else who will be there to share the load and permit you to take a vacation and have sick time. You will also have a highly motivated coworker, not just someone who is earning a paycheck. Partners can bring skills in areas that are complementary to yours. It may be necessary to have a partner to contribute capital and share the risk when things do not proceed as planned. Partners bring along their own networks of friends, colleagues, and professionals, which could be beneficial for your business. Cons of having a partner. You will have to share the reward if the business is successful. A partner can be a disaster if his or her judgment is not good. You will not be able to make decisions about the business without including your partner. Your partner might make decisions or take actions that you do not agree with. You will need to disclose and share any and all financial information with your partner. If you are 50-50 equal partners, then it may be difficult to resolve differences of opinion. You run the risk of a falling out and perhaps the necessity of one partner buying the other out if dissension arises. What is liability and where does it come from? Up next, what is a liability and where does it come from? A liability is something that a business owes, whether it's money or other financial or legal responsibilities. One of the important differences between various types of business organizations or entities is related to how responsibility is assigned. Who is liable? Who acts on behalf of the business? And who is responsible? Responsibility for these acts is known as liability. Liabilities arise as the business grows and come from activities such as the following: contracts, contractual obligations of the company such as loans, leases, supply agreements, or subscriptions can cause potential liability. Workers, hiring employees or independent contractors can cause potential liability. Partners, having partners or co-founders can cause potential liability, especially if those individuals do not have a written agreement. Product and service offerings. Issues can arise with products or services that are offered by your business, such as warranties, defects, or other harm. Regulatory compliance. If your business is in an industry that is subject to regulations, then lack of compliance with these regulations can be a source of liability. Timing and liability. When deciding whether to set up an official business entity such as a limited liability company, LLC, or corporation, you should consider the potential liability that your business may be incurring based on the stage that you are in. For example, if most of your business's activities are relating to prototype development, then your business may not yet be taking on a large risk of liability. As your business grows and faces more liability, you can change your legal structure. What type of business organization is right for you? Now we'll discuss the different types of legal structures you can use to set up your business. Sole proprietorship, partnership, limited partnership, limited liability company, LLC, corporation, S corporation, benefit or social purpose corporation, nonprofit. Up first, sole proprietorship. A sole proprietorship is one person alone who is running a business, even if he or she has not taken official steps to set up a business entity. For example, Maxine, a culinary school graduate, starts getting paid by friends and family to make wedding cakes. She would be considered a sole proprietor. Some characteristics of a sole proprietorship include the sole proprietor will have unlimited personal liability for the business. The income or loss from the business will be reported on the sole proprietor's personal income tax return, along with all other income, expense, and personal assets he or she normally reports. The sole proprietorship avoids the expense of forming an LLC or corporation. Many start businesses this way by default because they are unfamiliar with the other forms of organizations. Next, partnerships and limited partnerships. A partnership is similar to a sole proprietorship because even without taking any action to set up a business entity, two or more individuals working on a business can be considered a partnership. Using the same examples as before, Maxine, the culinary school graduate, continues to make wedding cakes but realizes that many weddings need someone to make appetizers as well. She and another friend come up with a name and sell package deals of appetizers and cakes for weddings under that business name. They would be a partnership. Some characteristics of a partnership include each of the two or more partners will have unlimited liability for the business. So in other words, two partners do not split liability 50-50. Both are fully responsible. The income and expense is reported on a separate return for tax purposes, but each partner then reports his or her pro rata or proportionate share of the profit or loss from the business as one line on the personal tax return. This is called pass-through taxation. Partners each have the ability to make decisions on behalf of the organization, so a formal agreement as to percent ownership and voting power is recommended. A partnership agreement should have provisions made for exit strategies, and you will need experts experienced in succession planning. If some partners have special skills or talents, the partnership agreement may allow some partners to veto or approve important decisions in his or her area of expertise. The partnership agreement should have buy-sell provisions that are clear about what happens to the partnership in the event of a disagreement and how the purchaser will pay for the portion of the business he or she is buying. You could also organize your business as a limited partnership. Limited partnerships have a two-tiered partnership structure. As an example, Jennifer and Alex start a consulting business whereby they both act as general partners, but after a few years decide to promote one of their employees to partner. Because their associate is young and relatively inexperienced in operating a business, they choose a limited partnership so the employee can be a limited partner. Some characteristics of a limited partnership include each of the general partners has unlimited liability for the debts of the partnership, but the limited partner's exposure is limited to the contribution that partner has made to the partnership. With certain minor exceptions, the income and expense reporting for tax purposes is the same as for a general partnership. Similar to a partnership, a limited partnership should employ a partnership agreement that sets forth important provisions, such as how the partners will make decisions, split up ownership, and what happens when a partner quits, retires, or dies. Another way to organize your business is through a limited liability company, also known as an LLC. A limited liability company, LLC, combines the limited liability for owners that a corporation would provide with the flexibility and pass-through taxation a partnership would provide. As an example, Susan, Bianca, and Hillary, three experienced computer engineers, decide to start an IT consulting company where they make house calls to help people install and fix their home computer equipment. They choose to be an LLC where each of the three of them shares voting rights and the income and expenses of the business equally. An LLC has the benefit of protecting owners from being personally responsible for the liabilities of the business. In some states, the LLC can choose to be taxed like a corporation or like a partnership, so the owners can enjoy the pass-through nature of the expense and income reporting. The LLC is flexible because it can be managed by all of the members or can have centralized management in one or more of the members. One downside to an LLC is that generally venture capitalists will not invest in an LLC. However, if venture capital funding is not required soon, a business may want to form as an LLC because an LLC can be converted to a corporation if this becomes an issue. An LLC is governed by an operating agreement amongst its owners, also called members, which is similar to a partnership agreement. Some individual business owners may also choose to establish an LLC rather than a sole proprietor for tax and liability purposes. If an LLC doesn't make sense, you could organize your business as a corporation. A corporation provides limited liability for the owners called shareholders or stockholders and has a more formal business structure than an LLC. For example, assume 4 recent engineering graduates decide that they're going to start a company to sell personal rocket packs. They know that they will not be able to make the company work without large amounts of investment from a venture capitalist, aka VC. They choose to start their business as a corporation right from the beginning since VC financing is a necessity, and this business entity will be compatible. Some of the characteristics of corporations include: in general, none of the shareholders in a corporation is obligated for the liabilities of the corporation. Creditors can look only to the corporation's assets for payment. The corporation has the downside of being subject to double taxation under federal income tax rules. The corporation files its own tax return and pays taxes on its income, and then, if the corporation distributes some of its earnings in the form of dividends to its owners, the recipients must pay taxes on those dividends, even though the corporation has paid taxes on its earnings. A corporation is more difficult to maintain than a partnership or LLC in that corporate laws require formalities from corporations, such as appointing a board of directors and officers, holding regular meetings of the board and shareholders, and providing owners with annual financial reports. Then there's an S corporation. An S corporation or S corp is not a different type of entity than a corporation. In fact, they are registered and organized the same way. However, if the corporation's shareholders meet the tests that are set forth by the U.S. Internal Revenue Service, then the corporation can make an election to be an S corporation for federal income tax purposes. An S corporation is treated as a partnership for tax purposes, although it is treated as a regular corporation for other purposes. If your company is doing social good, it could be organized as a benefit or social purpose corporation. A benefit or social purpose corporation is generally similar to a corporation in the way that it is organized and operated, except that in its articles of incorporation, or sometimes called a certificate or charter, the corporation sets forth a social purpose. The social purpose is hardwired or included in the business decisions of the corporation because the board and management must consider the social purposes set forth in the articles. The board of directors is protected when it makes decisions that further the social purpose, even if the decision may not make the most profit for the shareholders. A benefit or social purpose corporation may be able to be treated as an S corp. Companies that organize as benefit or social purpose corporations typically do so not because they want to enjoy tax benefits, but because they perceive some benefit in adopting a social purpose. For example, Patagonia Inc., an outdoor products company, became a benefit corporation in California in 2012. Their founder, Yvon Chouinard, said, "Benefit corporation legislation creates the legal framework to enable mission-driven companies like Patagonia to stay mission-driven through succession, capital raises, and even changes in ownership by institutionalizing the values, culture, processes, and high standards put in place by founding entrepreneurs." And finally, there's nonprofit. Nonprofit businesses are beneficial because they typically are not subject to income taxes. They are organized for an acceptable public purpose, such as charitable or religious purposes, and must be approved by the taxing authorities, such as the IRS, to enjoy tax-exempt status. A downside of a nonprofit is that there are generally no private owners of the organization. The assets of the organization belong to the public and cannot be used for purposes that do not further the nonprofit mission. Steps you should take to organize your business. No matter what business organization you choose, there are certain steps you will need to take to organize your business and minimize risk. Here are some examples. Decide how ownership will be divided. Take into consideration each owner's contributions to the company. Be sure that contributions to the company, money, assets, talent, intellectual property, are always documented, and that the contributor is clear about what he or she is receiving in return for the contribution. Operate under a written agreement. Even early on in your business, when you may not have a product or service to offer yet, you may be working with other potential co-founders or partners. You should be sure that expectations are clear as to what each person's expected role will be once the business entity is officially formed. Document intellectual property ownership. Ensure that all registered forms of intellectual property, such as patents, trademarks, and copyrights, are assigned to the company via a formal written assignment signed by the inventor, author, and creator. Issue the founder stock or ownership shares as soon as the entity is formed. In an LLC, the ownership is defined in an operating agreement signed by all of the owners. In a corporation, the stock is typically issued by having each recipient enter into a stock purchase agreement with the company. Work diligently to complete these documents promptly after registering the LLC or corporation in consultation with your attorney and tax advisor. Keep track of agreements. Be sure that when you enter into agreements, such as non-disclosure agreements, employee or independent contractor agreements, leases, etc., that you obtain a copy with both parties' signatures. Keep all signed agreements in a location where they can easily be accessed and tracked. Understand which tax laws affect you. Before making any decisions as to what sort of entity to choose, what state to incorporate in, or who should be an owner and for what percentage share of the company, you must seek the advice of a tax advisor to fully understand the tax implications associated with those decisions. Understand other laws and regulations that affect you. Every business must comply with a variety of laws, and consulting with a business attorney will help you to understand which of these apply to your business. Professionals that can help. If all of this feels overwhelming in any way, don't worry. Starting your own business may feel overwhelming at times, but there are experts who can help you navigate this process and lighten your load. This enables you to focus your energy and attention on the areas of your business that you excel in, while also ensuring that nothing important falls through the cracks. Here are a few examples of professionals you can contract to help you organize your business. Corporation filing services, attorneys, accountants, payroll and HR services, benefits consultants, insurance brokers, pre-employment screening. Top 10 do's and don'ts. The top 10 do's. 1. Use a pro and con list when deciding if and whom you should have as a partner. 2. If considering a partner, look for someone with complementary skills to your own. 3. If you take on a partner, be sure to have a partnership agreement in place that outlines how decisions will be made even if you don't agree. 4. Consider whether your business is incurring liability or at what stage it might incur liability when deciding whether to set up a corporation or LLC. 5. Consult with a lawyer when deciding on what form of business best suits your needs. 6. Be sure that all partners, founders, and/or other individuals working in the company assign their intellectual property rights to the business through a formal signed agreement. 7. Consult with an accountant or tax advisor before setting up a business entity. 8. Use an intellectual property lawyer to protect your intellectual property rights, such as your trademarks, company name, logo, or product. 9. Outsource your payroll responsibilities to a payroll service provider, as getting the calculation of pay and withholdings wrong can create liability for your business. 10. Obtain insurance for your business even if you have set up a limited liability entity like a corporation or LLC. The top 10 don'ts. 1. Don't use a sole proprietorship or general partnership if you intend to limit your liability. 2. Don't start a corporation without consulting a lawyer or tax advisor first. 3. Don't fail to issue the founder stock as soon as a corporation is formed. 4. Don't sell stock in a corporation without consulting an attorney and obtaining required governmental approvals. 5. Don't fail to pay your payroll tax liabilities on time. You may be personally liable even if you set up a limited liability company, such as a corporation or LLC. 6. Don't sign a lease or important agreements without your lawyer's advice. 7. Don't start your business without retaining an accountant and having an accounting system in place. 8. Don't start a business with a handshake agreement amongst partners or founders. 9. Don't rely on your LLC or corporation as protection from personally guaranteed liabilities. 10. Don't fail to take the advice of your lawyer and accountant seriously. Congratulations! You have now completed this session of your course. Now that you know all the ways you can structure your business, it's time to get to work. Determine which type of business organization makes the most sense for your stage of development and get started. If you are writing your business plan while taking this course, take a moment now to include any information about your business related to this session. This information and more is available for you to view and read for free online. Moby's free business plan template and other worksheets, checklists, and templates are available for you to download.
This session can be taken on its own or as a part of a full course to earn a certificate of completion and/or digital badge from Moby and Santa Clara University. If you're taking this as a part of a course or want to enroll, be sure to log on and take the corresponding quiz or final exam as appropriate. You can access more topics, courses, and helpful information for your business at www.scu.edu/MOBI.